Dan, I'm just waiting for there to be a critical mass in the attendees. Okay, it looks like people are getting in. The rush has slowed down. Hi everyone, welcome to the final seminar in my tenure as chair of the section, where our seminar today is on the basics of long-term care planning. I appreciate the section's participation in all of these seminars. It's been kind of fun to have to adapt on the fly, but we did it, and with luck, we will be having our regular seminars next year. That's our plan. I want to just let you guys know that we're going to be monitoring the Q&A feature here. I don't think the chat feature is enabled, so if you have questions, we can collect those, and Dan will answer some of them as he goes along, and if it's appropriate, and some of them as we move forward. So you guys, if you've attended these seminars before, you know who Dan is, but I'll go ahead and just do a little introduction. Dan is the founder of the Elder Care and Special Needs Law Practice of Daniel D. Munster. He received his BA from Vanderbilt and his law degree at the University of Detroit, where he was a member of the Law Review. He's been practicing in this area longer than I should tell on him, and has spoken often at our events. He at once was a staff attorney with the Senior Citizens Law Project of Atlanta Legal Aid, and he regularly advises his clients regarding complex issues of nursing home, Medicaid planning, elder care planning, long-term planning. He's a member of the National Academy of Elder Care Lawyers and the Atlanta Estate Planning Council. Everyone welcome Dan.
Thank you very much, Patricia. Glad to be here. Without further ado, I'm going to go ahead and share my screen, which is the presentation for today. And first of all, I want to thank you, Patricia, and the Fiduciary Law section for the opportunity. I think it's a great topic, a topic that hasn't been discussed for a while, even pre-COVID. We hadn't done a basic elder law program. And so I'm thrilled that we're able to get this information out there. There have been a lot of changes in the laws in the last few years, and there's also been a significant development in Georgia's home-based Medicaid program, which actually will play a significant role in the substance of today's discussion. So a lot to talk about. So the first slide, what is long-term care? I guess the easiest way to explain it is what it's not. Often we advise our clients in all kinds of different topics as to define things by what they're not. So long-term care is nothing that is requires doctors, requires nurses, requires licensed therapists. We're literally talking about non-medical, custodial, personal services and support and companion care. From a acronym standpoint, you'll hear the phrase ADLs thrown around a lot, activities of daily living. And so those primary activities of daily living are, as we age, these are the things we need help with, and these are what fall under the heading of long-term care. Those 5 categories: dressing, bathing, toileting, transferring, and feeding. Beyond those, it also can include medication management, transportation, meal preparation, laundry, grocery shopping, general housekeeping, basically all of the things that we do all day, every day for ourselves, and to an extent maybe take for granted, because there may come a day when we might not be able to do those things. And so, as you can see, the final bullet point on this slide, 70% of people who reach the age of 65 statistically need long-term care at some point between 65 and the point that they pass. So in terms of a husband and wife, that obviously suggests that at least one and possibly both might at some point need long-term care. And this is really why the topic and elder care overall has become such a priority because baby boomers are aging, and now baby boomers are in their 70s and 80s and 90s, and they're needing assistance with all these different types of care, which, as we'll talk about, do not qualify for coverage under Medicare. And as a result, figuring out how to finance these becomes the topic of discussion. So before talking about the way to finance them, I thought it was important to clarify where long-term care might be received. Again, contrasting it from where it isn't received, typically the first place that you would cross off the list would be in a hospital. But also there's nowadays such a thing as a long-term acute care hospital, or an LTAC unit, often linked to a hospital, and which is not considered long-term care from a custodial personal services support standpoint. All right, so on this list, in descending order, long-term care is available or can be provided in a nursing home, in a memory care assisted living facility, an assisted living facility, a personal care home, an independent living facility, and even in a private residence. So let's talk about a couple of those things. I guess I want to leave nursing homes to last. An important point that I often end up having to make for clients, and y'all might appreciate knowing, is that memory care assisted living is not nursing care from a regulatory standpoint and from a Medicaid financing standpoint. So if an assisted living facility has a secure unit with a keypad and more caregivers because the residents suffer from some sort of cognitive impairment and need greater help than an average person, that's considered memory care assisted living. And those services provided at the high end of assisted living, as we'll talk about in a moment, do cross into nursing care. The difference is that Medicaid won't pay for it at a memory care assisted living facility, which private pay is $5,000 or $6,000 or $7,000 a month private pay. So for whatever reason, a lot of my clients end up misunderstanding that when you go from regular assisted living to memory care assisted living, that suddenly counts as nursing home care, and that's unfortunately not true. Later in this conversation, we're going to be talking more about personal care homes because Georgia has quite a few of them that participate in our home-based program. The general line that divides personal care homes from assisted living facilities is basically size. My understanding is when those regulations were changed a few years ago, that 25 beds or less is considered a personal care home, and bigger is considered an assisted living facility. In my experience, most personal care homes are not 25 beds. They're 4 or 6 or 8, and it's literally somebody's personal residence where they've gotten certified to provide in-home care to customers in their home. The services provided are still the same long-term care ADL support, but on a much smaller scale. That potentially can be very valuable when you're talking about a client who has behavioral issues or some other reason why they might do better in a small, less chaotic setting. And so there can be times when a personal care home is a great fit. On the bullet independent living facilities, at some point during this conversation, I'll probably end up getting on a soapbox on more than one occasion, and this is one of them. For whatever reason, I see clients regularly who are not independent being admitted to independent living facilities with the expectation that they will then pay for ADL support. And often that ADL support is linked to a single company that is authorized to provide care in that independent living facility. which also happens to be under the corporate structure of the owner of the independent living facility. So it seems to me that it's a bit of a way around being licensed as an assisted living facility, but everything is happening under the same roof. Not sure if that's appropriate or if there's any legislators listening and they might want to look into that. But there's a reason why independent living facilities are licensed and considered separate, and so that's a little bit of a soapbox. And then of course private residences. In-home long-term care is actually the most expensive option of everything on the list here. For 24/7 in-home care, you're looking at somewhere in the neighborhood of $15,000 a month. Obviously, that's not affordable for most people, and yet it's it's a great option if you can. There are other states where that is an option. I got a call yesterday from a woman who's moving down from New York. Her mom actually is in their HCBS program and gets only 12 hours a day. She wants more, and she was wondering if in Georgia we can offer more. And we can't even offer anything close to 12 in our program. And so certainly we don't have 12 or 24-hour in-home assistance through Medicaid because it's so expensive. So the last topic here, nursing homes. This is a very important point as you discuss residential settings with your clients, that often people refer to nursing homes as a skilled nursing facility, the operative word being skilled, when in reality, 347 of Georgia's 359 skilled nursing facilities are actually dual certified. So they provide both skilled nursing and what's known as intermediate level nursing. And a couple of slides down, we're going to look at what intermediate level nursing care actually is. Why this is a big deal is because it means that 96% of all the nursing homes in Georgia accept Medicaid. And getting all the way down to the very bottom of the slides, I carried over a couple of slides from a presentation I did at the Fiduciary Law Institute a couple of years ago relating to pitfalls and myths and urban legends. If we get there, which hopefully we will, one of them actually is this idea that if you're in a nursing home and your payment source is Medicaid, then by definition, your care is going to suffer or be deficient or in some way less than someone else in the same facility who's paying privately. And it's important that we dispel that urban legend because, as I just said, 96% of our nursing homes, they're good ones, average ones, and bad ones, virtually all of them participate in Medicaid. And as a result, it's not necessarily accurate to say that if you're ultimately able to get Medicaid help, that's going to change the quality of your care. Really what it comes down to is how do you get a bed in a good nursing home where you can later qualify for Medicaid? Because it is very uncommon to be able to access a nursing home. Sorry about that. That's my phone that you all get to listen to. It is difficult to access a better nursing home if your source of payment from day one is Medicaid. And so I guess just a 60-second tangent on that point, all of those 359 nursing homes are compensated on the same model. At the top of that food chain is Medicare, post-hospital rehab. The middle tier are the private pay long-term care folks. And then the bottom are the Medicaid folks. And the law actually says that nursing homes are permitted to ask your client, or you if you're trying to help a family member, to explain to them what your finances are, what your client's finances are. And if what they see isn't enough, they're allowed to say no thanks. And so it is relevant in the sense, Medicaid is relevant in the sense that if all you have from day one is Medicaid, it can be tricky. All of that is to say that if you have a hospitalization and you have Medicare, or if you have a loved one or a client in assisted living who's spending down, it might be a better choice to transition into nursing care while you have a little bit of money left, because you're going to need some sort of carrot to dangle in front of that admissions director to get a bed, rather than walking in the door of a well-respected nursing home asking for a bed with nothing to offer besides Medicaid. But the point being, 347 places, that's plenty of nursing homes, many good ones. Medicaid does not mean or equal deficient or defective care. From a cost standpoint, these numbers are taken from Genworth. They track these costs on a national basis and also on a state basis, and so I've included these numbers here for you to look at just to get an idea. Here in Metro Atlanta and in the other larger metropolitan areas in Georgia, it's safe to say that the numbers you'll see are closer to the national average as opposed to the numbers you see here for the state of Georgia. And so it isn't uncommon for a nursing home in Metro Atlanta to cost $9,000. This chart does not break out the cost of memory care assisted living versus traditional assisted living. And so just as a quick sidebar about that, here in Metro Atlanta, non-memory care assisted living can be as low as $3,000 a month or as much as $6,000 or $7,000 a month in a white glove concierge type environment. Memory care assisted living is at this point starts at about $5,000 a month and jumps up to maybe $7,500 a month. So the Genworth numbers here for the average cost for assisted living are probably a little bit lower than what I see for my clients. If you start multiplying these numbers by 12, as in months of the year, you start to see that the numbers can get pretty big and easily exceed $100,000 per year for nursing home care. This is why long-term care planning has become such a critical topic, and why we have several hundred people on this call today. I think it's great that people want to learn about this, both for your own family and for your clients' families, to figure out how to plan ahead for this.
Hey, Dan,
Yes.
we have a question that may be appropriate for you to answer right now. And that is, what are the differences? What difference should be expected in the level of care or services when an individual switches from private pay to Medicaid?
Very good and fair question, and I'm pleased to say that the answer should be absolutely no difference. And the reason that I feel pretty confident saying that is, first of all, that federal law says that it is illegal for a facility to retaliate, meaning diminish care, when somebody converts to Medicaid. In addition, it is not permissible for the caregivers on the halls to even know whose payment source is private pay and whose payment source is Medicaid. Only the business office and admissions folks even know that information. So after 25 plus years and 1,000 plus clients that I've helped to walk through this process, I've never had a single family come back to me and express regret that they pursued Medicaid help because the quality of care changed. It just, that's not the issue that's going to drive care. The first thing that's going to drive care is getting a bed in a better facility from the beginning, which puts us back in a discussion of being able to go in under Medicare or being able to go in as a private pay resident and then subsequently qualify. Once you're in, I'm glad that question came up because the law actually flip-flops. When you're outside trying to get in, they can ask about your finances and they can decline to do business with you if they choose. However, if after you're admitted, you qualify for Medicaid, then as part of their contract with Medicaid, they have to agree not to kick you out, not to retaliate, not to reduce your care in some way. And, there was a point at which I was skeptical, but after so many years and so many clients, I'm comfortable saying that the quality of care shouldn't change. All right, so back to the dollars and how to afford care. We've talked about what it is and where it's provided, how to pay for it. Obviously, the first thing on the list I've included is Medicare, and I've then crossed it out. And the reason is that Medicare isn't a potential solution for long-term care. Medicare is major medical. Part A covers hospital. Actually, let me rewind. To contrast the two, Medicare is national, but Medicaid is very state specific. That's a common question that I get from clients. Understanding that Medicaid in Georgia and what we're talking about today, it could be completely different in Oregon or Arizona or New York or anywhere else. And so don't take what you hear today outside the boundaries of the state of Georgia. Medicare, on the other hand, is national. In Georgia, there are about 30, actually it was 35, now 34 classes of Medicaid. Whereas with Medicare, there's just 4. Part A is hospital coverage. Part B is outpatient doctor office visits. And I'm generalizing here, but for the most part. Part C are the Medicare Advantage plans. And Part D is the prescription drug Medicare coverage. Those 4 types are the same everywhere. The different companies that offer drugs, for example, and the formulary they offer, those things can differ. But in terms of what's covered, they all are the same across all the state lines. And so nowhere under A, B, C, and D is long-term care covered. The best you're going to get is following a hospitalization of at least 3 days, you can qualify for up to 100 days of Medicare assistance with post-hospital rehabilitation. That topic alone, I could spend 15 minutes on, and so I'm not going to, but I will note for people who are interested in that, the website medicareadvocacy.org, medicareadvocacy.org. Just go there, click on topics, scroll down to the improvement standard, and read everything you can lay your eyes on regarding how the improvement standard is not the correct standard. If you have a client or a loved one in a skilled nursing facility and their Medicare is being terminated, the reason you'll be given is that mom is no longer improving, she has plateaued, and therefore it's ending. The problem is the improvement standard is not correct. And so go to medicareadvocacy.org, read about the improvement standard and what the correct standard is, and then you'll be in a strong position to advocate for your clients. That website's a great resource actually because they have various self-help kits, appeal kits, PDFs that your clients can print and bring with them to help educate skilled nursing facilities that are using the wrong standard. And so it's just a great resource. I recommend that you bookmark it. So Medicare isn't a solution. The next bullet on the list, private payment. We've been talking about that. $7,000 to $9,000, even $10,000 a month for nursing home care. Let's say $3,000 to $7,000 a month for assisted living care, and $0 to $15,000 a month for in-home care. Those numbers are the numbers that strike fear in our clients' hearts, and that's why they need our help understanding these other options. Patricia, I believe this is a 90-minute session, right?
Correct.
Okay, thanks. So the next 2 bullet points on the list, I'm not going to spend a lot of time on since the subject is long-term care Medicaid in Georgia. But I do think it's important for us to spend just a couple of minutes on this alternative, because there are times when, at least from my standpoint, Medicaid planning really doesn't make any sense, even though it might be possible. In fact, I'll give you as an example. I had a call yesterday from a gentleman and his wife whose net worth was in the 1.5 to 2 million range. Their home and non-retirement savings were only $350,000, but they had over 1.5 million in retirement accounts, and they had substantial monthly income. They called me to learn about how they could invite the government into their affairs and qualify for Medicaid someday. And when I asked them, were you aware there's such a thing as long-term care insurance? And there's also hybrid investment products that have a long-term care component to them, which would allow you to plan for the cost of your care without necessarily inviting the government into your affairs, without trying to pound a square peg into a round hole. Have you thought about that? And their answer was no. They just said, we were told the sky's falling and we've got to figure out what to do, and we need to do it yesterday. There are times when that might be appropriate. On the other hand, I think the fella really appreciated when I explained to him, well, first of all, we unearthed the fact that his company offers group long-term care insurance, which he wasn't even aware of. And then I gave him a little bit of information about long-term care insurance, about hybrid products. And by the time we were done, I had talked myself out of a client or an opportunity to represent them. But I think that they ultimately will be served best by going out and spending $500 or $600 a month of their substantial income, getting a good joint policy between the two spouses, and never having to ask Medicaid for help. Of course, I encourage them to contact some other attorneys of you out there to get second opinions, and who knows, maybe they'll still go down that road. But long-term care insurance and hybrid products are a great solution for people in that range where, once you have $3, $4, $5, $10 million, you can write checks for $8,000 a month and not worry about it. If you have anything less than that, well, then you're probably a good candidate for long-term care planning. But somewhere in that range they were in is something that I sort of feel like is a good opportunity to look at these other investment products before you look at Medicaid. Next thing on the list, again, technically outside the scope of this conversation, but I still want to pause briefly on this, is the VA program that so many people have heard about, the wartime pension. I've listed it here as aid and attendance because that's what everybody calls it. But all that really is the highest payment level of the VA wartime pension. The VA pays benefits out to veterans. This isn't the ability to go to the VA hospital I'm talking about now. This is literally a monthly paycheck, which for the widow of a veteran is $1,244. For a veteran who's not married is over $1,900, and for a married veteran is over $2,200 a month. So we're talking about a big enough check that it could make the difference between the ability to afford assisted living or not. So from that standpoint, just keep in mind the VA pays out pays out checks, and I shouldn't say the VA. Military service can result in a payment happening on one of three tracks, either from DFAS or from the VA. The first is if somebody served 20 or more years, then they're going to qualify for a retirement as a career serviceman. That's not what I'm talking about in terms of the wartime pension and aid and attendance. The second track is the compensation track. So if somebody has suffered a service-connected disability as a result of their service, they will be rated anywhere from 10 to 100%, and they'll get compensated for the harm that they've suffered. The retirement track and the compensation track are not means tested. So it doesn't matter how wealthy the retired veteran is or the widow is, they'll still get their retirement and they'll still get their compensation. The third track is the track where a good bit of planning can happen, and that's the wartime pension, where if the veteran served at least 90 days active duty, at least one day during wartime, and was not dishonorably discharged, then it's possible that if they can show need, the VA will chip in towards the cost of their long-term care. This isn't a paycheck so that they can travel the world on a cruise. It has to be linked to medical expenses. It's a program that's designed to assist veterans of modest means, meaning less than about $130,000 of net worth besides their home. But if that modest net worth is circling the drain because their medical expenses exceed their income, then that's when the wartime pension can play a significant role. So definitely explore that more if you have a loved one or a client that is a veteran or the widow of a veteran.
Hey, Dan, we have a couple more questions. Do you want to keep answering these during, or do you want to hold them until the end?
Let's keep trying to answer them now, and then if it gets crazy, then we'll try to change.
Okay, so one that is relevant to what you're asking right now: can an individual receive VA aid and attendance and ABD nursing home Medicaid simultaneously?
And the other one?
The other one was, is there a trusted organization that evaluates different nursing homes based on factors that families should consider?
So I'll take those in reverse order. There are a lot of nursing home compare type websites, none of which that stand out to me as any better than the other. Obviously, Medicare.gov has a nursing home compare tool with a 5-star rating system, but that itself with Medicare is based on self-reporting. So I think that most people in the aging community would say that all of those resources are, maybe partially reliable, but not perfect. On my website, I've got an FAQ on that topic where if people want to go there and scroll through some of those resources, they can. Having said that, I think the best resource is there's such a thing as an aging life care manager, formerly known as a geriatric care manager. These are private social workers, typically with a MSW, LCSW, or RN background, who work for your client or their family, and who get into the medical records. They go to doctor appointments with the client if they want. They intercede with admissions directors and help with placements. And so it's truly an advocate with the social work background that works for the family. And therefore, I think pursuing the help of an aging life care manager can be a crucial tool in addressing that question. The second question. What was the second question again?
Oh, it's receiving the aid and attendance benefit and the nursing home Medicaid.
Yeah.
Yeah.
The way that normally works, it's a little bit tricky, but the way it normally works is that if someone is in a nursing home and not on Medicaid, then their nursing home private pay bill is just a big medical bill that helps them to continue qualifying for the VA payment. However, if at some point the individual is able to qualify for Medicaid, then under normal circumstances, the VA will reduce that payment down to a payment of $90. And so, yes, they can coexist. And from Medicaid standpoint, there's actually a requirement that any veteran or widow of veteran must agree to go and apply for VA benefits if there's a veteran involved. So they can coexist. They often do coexist. A few times in my career, I've actually seen a pretty cool situation where a spouse in the nursing home is on Medicaid, and a spouse at home, typically the veteran himself, is actually still able to qualify for the aid and attendance while the spouse in the nursing home is on Medicaid. So yes, the answer is yes, they can coexist. They do affect each other. And that's as much as I think we have time for me to go into on that. But there's some more moving parts that it can actually make life difficult for a client if they have both. Number one, well, all right. So the VA payment, aid and attendance, is not income. When we get down to talking about income, I'll address that because that's a really big misunderstanding out there among nursing home business offices that are in the business of giving legal advice about whether or not they need a Miller Trust. So I'll come back to that.
So Dan, if you could just point, can you point some people in the audience to a good source for information on the aid and attendance benefit? I think that'll take care of this next question that just came in, and then you can go back to your prepared.
Um, Well, as I looked down the list of attendees, I saw a few attorneys out there who I know work in this area. If Drew Early, if you want to offer an answer in the Q&A for Patricia, feel free. My go-to resource is actually the Georgia Department of Veterans Services, a state agency. In addition, if you just Google the phrase VA aid and attendance, you'll find 5,000 websites. Many of which are run by attorneys on a for-profit basis. So I'm a little uncomfortable promoting any one versus the other. But you know, I think that I guess I will throw out, there is a software program out there available called VizPro, which I know a lot of attorneys use to help get applications submitted and filed. And so that's a resource folks might want to look at. So in the interest of time, I'm going to move on. The last two bullet points here are obviously Medicaid, which is our subject matter today. Nursing home and community care Medicaid I've broken out because of a really important point that has come to pass in Georgia, really sort of coinciding with COVID, or maybe preceding it a little bit. And that's the fact that Georgia's home and community-based Medicaid program that assists people with in-home care, which is called the Community Care Services Program, has only recently become accessible to pretty much everybody. Up until the last year or two, CCSP existed, but both because of underfunding and because of a different management system that has been changed, there were always long waiting lists. And as a result, if somebody were in need today of what CCSP provides, which on average is 4 to 6 hours a day, 5 days a week, let's say, if they need that today, then 6 months or a year from now, when they come up to the top of the waiting list, it's not going to be enough. And so CCSP was at least in the bigger cities where the slots were more difficult, they're divided statewide on a regional basis. So in the bigger areas, you couldn't get a slot anyways. So I want to spend some time about that with CCSP today, because now that waiting list has been eliminated. And so it's far more feasible for somebody to take advantage of CCSP rather than what used to be a fairly strong institutional bias, meaning you had to go to a nursing home to get help from Medicaid. So this slide is actually a slide of our HCBS overall, with the Elderly and Disabled Waiver Program, Independent Care Waiver Program, now COMP and now, and also the pediatric program. The one that I'm highlighting is the one in bold, CCSP. You can read for yourself what that includes and all those different bullet points. But think about it. If it's just for you yourself, or for your own mother or your spouse or some other loved one, where do you think they would rather be, at home or in a nursing home? And so the idea of a Medicaid, a more accessible Medicaid program that can help to keep people at home is instead of having to be a nurse in a nursing home, is a big win for Georgia. Many, many years ago, there was actually a lawsuit that I'll never forget, because in the pleadings, a statistic was quoted that has always stayed with me. I don't know if the numbers still work exactly, but I'm guessing it's not too far off. And that number was that the state can pay for 3.4 people to stay home via CCSP for the same amount that it costs for one person to have to be in a nursing home. So from that standpoint, you can see why it would make sense for them to expand and broaden CCSP so that more people can actually stay where they would rather be. And that's what we've now see come to pass. because of a little bit of extra funding, but also better management. All right. So again, adult daycare, alternative living services, that's the personal care home option, emergency response system, home delivered meals, home delivered services. So that's all the ADL support. And also respite care. Respite care are longer hourly visits, which allow the primary caregiver to actually go to the grocery store or go out to lunch with her girlfriends or go actually have some semblance of a life. So I can't tell you what a great resource this is. I'm not going to click on it, but you can see at the bottom of this slide, I've included an active link that you might want to go and read more about this there if you want. All right, so nursing home Medicaid and CCSP Medicaid, the two Georgia Medicaid programs that cover long-term care, have identical eligibility criteria. So everything I'm about to explain up to the point that we get to how cost share is calculated will be identical. Cost share is done differently, and it's taken me forever to figure that out, but I believe I've got it, and we'll run through some examples of that today as we go through this. So basic eligibility criteria, these are things unrelated to your client's money. The first thing that they're going to have to document is that the applicant is either aged, blind, or disabled. Aged is 65, and then I've included a couple of additional nuggets of information here about blind and disabled. SSA considers one to be blind if your vision can't be corrected to better than 2200 in your better eye, or if your peripheral vision is limited sufficiently, then you're considered blind, and that's sufficient even if you're not 65. Disabled is any one of those three check marks. And I always try to pause on this because, as many of you know, Social Security defines being disabled in the context of whether you can perform substantial gainful activity, meaning work. And so that can be tricky because it's entirely possible for, and there are many, brilliant, capable, accomplished people who are wheelchair bound and who, as you physically look at them, you might say that person is disabled because they can't stand up and walk around. That's unrelated to whether Social Security says they're disabled. And so it is possible for somebody to be completely incapacitated and traveling in a wheelchair through a straw they control with their mouth and still not be disabled for purposes of Social Security. And as a result, keep that in mind as you evaluate the disability component of this if somebody contacts you who's not yet 65. The next bullet point, length of stay, that one is a little bit misleading because it says you have to be able to satisfy a 30-day length of stay requirement. What that means is not that everybody is stuck paying for their first 30 days of nursing care. What it means is that you have to be in the nursing home for at least 30 days. And if you are, then your application can be approved back to the very first day if you were in fact financially eligible at that point. So there's a 30-day requirement. The residency question is one I do see come up quite a bit, so I want to pause on that briefly because of this idea of forum shopping. Because Medicaid is different in every state, there are times, especially for those of you who practice near Chattanooga or over near Augusta or down near Columbus, where people are literally jumping across state lines depending on what the law in the other state is. And so, I think there's a little bit of fudging going on there because I think that it is to take advantage of the different or better rules perceived, and yet it's happening. From a residency standpoint, if you click on that link, eventually what you'll find is that there isn't one. You simply have to be in Georgia and intend to remain here and not here just for a temporary visit. And so somebody can literally relocate here from New York with her daughter and qualify for Medicaid immediately as long as the intention is that you're going to be staying here. So that is a little bit, there are other areas of law. One that comes to mind is divorce. You can't just move to another state and get divorced the next day, and often they have a residency requirement for that. Point here being that there isn't a residency requirement for Georgia for Medicaid. Obviously, there's the issue of citizenship is a big one. You either have to be a U.S. citizen or a qualified legal alien. Anybody who came here after 1998, I believe, or I don't know, don't quote me. The link is there. If you've been here for at least 5 years and you came here legally, then generally you're going to be allowed to pursue all of the other classes of assistance besides normal Medicaid. But you do have to document that you're either a citizen or have a green card, or in some way you have legal status. You can't be illegal. And then finally, the level of care piece of this. This is the point I brought up earlier, the difference between skilled care and intermediate care. Skilled care is doctors and nurses. It's ventilators, feeding tubes, injections. It's physical therapy, speech therapy, occupational therapy, things that are provided and performed by people with a medical degree or a nursing degree, and are at a higher level than what we talked about earlier is long-term care. Intermediate level nursing care is long-term care. It's, you might say it's advanced long-term care or advanced custodial care, but it is still just custodial care. Help with dressing, bathing, feeding, toileting, transferring, medication management, meals, all of that. That is intermediate level nursing care. And again, that's why it's so important that virtually all of our nursing homes, all of our skilled nursing facilities, except for, 11, all the rest accept Medicaid and provide both skilled and intermediate level nursing care. So what is that? The next slide, and you'll have to forgive me because this isn't a super fancy looking slide, but this is actually right from the Medicaid regulations. And this is a chart that you might want to become familiar with, or you'll be able to educate your clients about, because this really helps to document what intermediate level nursing care is and how easy it is to establish that your client requires intermediate level nursing care. And so, skipping all the directions, I'll just explain what they say. It says up there that you basically just have to show at least one item in column A besides A1, so anywhere 2 through 8, and then at least one item in column B or column C. Column B are all of the cognitive dementia related topics, and column C are all of the physical and functional things like assistance with feeding or transferring or incontinence care, or dressing and bathing, those things. And so looking back to column A, down number 8, I've never had anybody come to me on behalf of a loved one who they thought needed long-term care, who said, "Mom's still managing her own medication." So it's very uncommon that somebody won't need that. In addition, they might be able to satisfy some of the other ones in column A. Column B, column C, common sense stuff. As long as you can show one item in column A and one in B or C, then you're not going to have a problem documenting level of care when you apply for Medicaid at some point. This is still an important piece of the picture because people who are in assisted living and who are running out of money, and as I said before, might want to think about transitioning into nursing care while they still have the ability to pay privately a little bit, they might be thinking to themselves, well, Mom's in assisted living, and therefore, by definition, she's below a bright line that divides assisted living and nursing home care. That's a misunderstanding, and in fact, those two lines overlap. And at the high end of assisted living, mom already is receiving intermediate level nursing care. And so it is possible for somebody who's in an assisted living facility to move to a nursing home on a private pay basis because they need intermediate level nursing care. I know that sounds a little strange to go before you run out of money, but remember, if you run out of money, you're very unlikely to get a bed in a good nursing home. And so the somewhat daunting way that I often explain this to people is that, yeah, you could spend your mom's last $60,000 at her assisted living facility, but doing so could very well doom her to being in a bad nursing home the rest of her life. Is it really worth that to spend her last $60,000 over the next 12 months if you know that she's going to outlive that money one way or the other? Or might it be better to leverage those dollars to get a bed at a better nursing home? And so understanding this chart and what an intermediate level of care is a big piece of understanding that social work point that I just shared. All right. So now we're going to get into the financial criteria that drive Medicaid qualification. The 4 pillars of eligibility that I often describe for clients. The first is the medical level of care. The other 3 pillars on which the tabletop of Medicaid sits, the other 3 pillars are financial. One is the income test, one is the asset test, and one is the transfer test. If we could somehow ask for a show of hands, we would get 296 hands shoot up that would all say, I know enough to be dangerous, and I've heard about a 5-year look back period, and I'm pretty sure there's an income test, and then there's this Miller Trust thing. So by the time I get done with these next few slides, my goal is for you all to, who don't already understand it all, for you to be exposed to all that, keep it separate in your minds, and be able to evaluate your clients and their potential eligibility under those 3 distinct categories. All right, so the first one, income eligibility. The income limit is currently $2,382 a month. That number changes every year and is calculated based on 300% of the annual SSI amount, which is currently $794. The number is gross. And so when your client tells you that they get $22.96 from Social Security, and that's below $23.82, you unfortunately get to tell them that they fail the income test because $23.96 is net. And after you build back in the Medicare Part B premium of $148.50, the applicant is over $23.82 and fails the income test. So gross is an important thing to remember. Another important thing, which is the parenthetical I've included, is that when Medicaid does the analysis of income eligibility, they are only going to look at the income of the spouse in the nursing home or the CCSP applicant. And so that's very helpful because one spouse alone could be under that. It's a lot harder for 2 spouses to be under that. And so it's definitely important to remember it's only the spouse who's applying for assistance. When we get around to the cost share and the patient liability calculation, the spouse's income does come back up at that point. But back here, when we're just talking about can we get on Medicaid in the first place, the answer is spousal income doesn't matter. I have 2 clients right now who have annual income. Their spouse has annual income over $100,000 a year because they're still working. And unfortunately, they have a spouse that needs nursing care. The fact that you have a spouse earning 6 figures of income as a stay-at-home spouse, or I'm sorry, as a community spouse, doesn't affect eligibility. It does affect sharing, but it doesn't compromise the ability to get help. If somebody is over 2382, that's when this thing called a Miller Trust or a qualified income trust set comes into play. QITs are a federally established trust, which Georgia must recognize as a cap state. In the federal law, which sets up the authority to create a special needs trust, that is where you find the qualified income trust statute. Essentially, this is a trust that's not designed to hold assets. It never owns real estate. It never accumulates stocks and securities. It's just a monthly conduit of the client's income and functions as a laundry machine to cleanse their failure of the income test. As long as your client funnels enough of their income through their trust each month and then back out according to the rules, then Medicaid will forgive the client's failure of the income test. Remember, as I said, you have to funnel it back out according to the rules. What that means is the income you put in doesn't accumulate there. Your client doesn't get to spend it on luxurious items. 100% of your client's income is spoken for, either in terms of the nursing home cost share, the CCSP cost share, health insurance premiums, or a spousal or dependent child diversion. But the point is, at the end of every month, that qualified income trust balance should be back to zero. So this account never accumulates anything, and it is literally just a monthly conduit. Those trusts can be established in real time. So there's no, this whole thing about the 5-year look back period is not impacted by, the qualified income trust is not bound by that. So it's, at least, from my standpoint, my practice model, clients don't engage me to prepare a trust that they may never need. So if somebody says, I'm over the income limit, I'm 67 and I want to get a Miller trust set up in case I go to a nursing home someday, maybe I'm just a bad business person, but I'm typically going to respond to that by saying, you can do it at the time of need. You may never need a nursing home or Medicaid. So do you really want to invest in the creation of a trust that you might never need when you can do it at the time of need? Most people appreciate that, and so they leave it alone, at least temporarily. Now, some of you might be wondering, all right, well, what about the issue of capacity? And what happens if at some future time when they need the trust, you have a problem with their ability to execute it or their agent? And so this is why I think a lot of folks out there in the estate planning community now already do include something in their standard power of attorney that authorizes the creation of a qualified income trust under 42 USC 1396 PD4B. In addition, if you go and you look at the Georgia Trust Code and you look at the formalities to create an express trust, what you'll see is that a trust can be signed into existence by somebody via power of attorney, as long as the power of attorney expressly gives them that authority. Unless, and then right in the statute is the federal site for this qualified income trust, where a power of attorney which is silent is still sufficient with respect to one trust in Georgia, and that's the Miller Trust. And the reason that's there is because years ago, people were having to go left and right to get conservatorships exclusively to get a QIT set up. And so we got that added to the law, and now that's not necessary. All right. So in terms of evaluating your client's income and whether it's counted or excluded, I've provided some examples here for you to scroll through or scan down. Examples of exempt income. The first thing that I'd call attention to is number 2, VA aid and attendance. That payment, which typically consists of either aid and attendance or what is called unreimbursed medical expenses, is excluded by Medicaid. And so if your client gets a $1,500 Social Security check and a $1,244 aid and attendance check, they do not need a Miller Trust, even though the grand total is $2,744. And the reason is that the $1,244 VA payment does not count against the $2,382 limit. None of these other things are included on that limit. I'm sorry, included against the limit. And let's see, what other ones do we want to talk about? Actually, conversion of a resource. That one is interesting to me because, well, first of all, the rule: if you sell your car and you get a $9,000 check and you deposit it, just the receipt of that income, that deposit doesn't count as income. That's a common sense thing from a tax standpoint, but in general, Medicaid sees deposits and they start thinking income. So conversion of a resource, not income. However, I've never seen Medicaid raise this issue before, but if you scroll down the chart in section 2499 of the manual, you'll see that capital gains are actually listed as countable income. And so theoretically, if somebody sells a capital asset, which is a conversion of a resource, there's an argument that the capital gain that's experienced should be reported and count as part of cost share. I've never had a caseworker raise that or bring that up. All right. Examples of countable income. Where should we pause there? I guess the first place I'll pause is to contrast exempt income number 1 and countable income number 9. Believe it or not, if somebody receives child support, that's not income, but if they receive alimony, it is. In addition, and this is especially frustrating if you're the one paying alimony, that's not a deduction when it comes to the patient liability budget. And I'm not really sure what the solution to that is, because the Superior Court judge who ordered the alimony must be paid. That order is inconsistent with the Medicaid rule that says patient liability budget is going to be set without regard to that alimony obligation. Arguably, you can't get there from here, but that's what's in the rules. Let's see, what else? Number 8, countable income, retirement account distributions. That's a big deal, because when we get around to talking about assets, a huge takeaway, hopefully you guys will take away from this discussion, is the idea that retirement accounts in Georgia are either exempt or automatically exempt or can be made exempt by virtue of periodic distributions. And so, yes, those periodic distributions pop up on this slide as part of the income analysis. But if that, including that distribution of, let's just make up a number, $500 a month, purchases the exempt status of a $250,000 IRA, what would you rather have? Or what would your client rather have? Pay $500 a month more in your monthly bill and not have to burn through the $250,000 IRA, or burn through it all and then go on Medicaid later? Most people would say, go on Medicaid now and buy the exempt status of that retirement account through the distribution. Countable income number 4, military retirement and disability. Those 3 tracks I talked about before. VA aid and attendance is up on the exempt side, but if you receive a retirement or compensation, that is going to be visible and does count as income. Additional pieces of that countable income analysis: loan repayments and net rental income. Real quickly, promissory notes are part of the nuts and bolts of being an elder care attorney. And when your client receives repayments back of money that they've lent out, all of the payment, including principal, is part of their monthly income. Net rental income, that's a really helpful one, because Georgia law allows somebody to rent out their home place. Well, if somebody's single and their house is going to be subject to estate recovery and they don't want to do any sort of exceptional planning with the sale of the home, they can rent it out. And the rent gross can then be used to finance the ongoing expenses of the house, including property management. So you get to deduct ordinary and necessary expenses, and what's left does go towards your monthly cost share. That's actually a good thing from an estate recovery standpoint, because for every dollar more you pay each month, $1 less Medicaid pays, and therefore $1 lower their Medicaid lien against that house will be in the future. And so, especially more and more lately, as people are wanting to hold on to real estate as it goes up and up in value, is the idea that you can rent your home if you'd like. All right, so that's income eligibility. Resource eligibility. When resource eligibility is determined, Medicaid is going to divide all of your clients' assets into two columns. The next slide you'll see category C is exempt assets. This slide, category B, are the countable assets. When we get around to talking about exempt assets, or I'll just explain it now, that there is no limit. For someone who's married, there's no limit to the value of your exempt assets. For someone who is unmarried, the limit is $603,000 on their home place, and then no other limit anywhere else. The difference is that with countable assets, you do have these limits I've included here in bold, including $2,000 as the limit for someone who's not married. The limit for someone who's married is much higher, $132,380. Of course, 130 doesn't go as far as it used to. And so the typical married client that an elder care attorney is helping is someone who has assets countable in excess of 132. Well, what if it's 264 or 396? It's still exposed to erasure if the bill is 100 grand a year. And as a result, those are kind of the clients who fall in the crosshairs of a traditional long-term care planning client, is somebody with excess countable assets over these numbers. All right, so the note underneath married applicant and community spouse, I want to pause on that briefly for a couple of reasons. The first is that the rule changes. Once someone is on Medicaid, then every year thereafter, their eligibility will be recertified once every 12 months, with the understanding that the person in the nursing home will be expected to have less than $2,000 of savings, and the community spouse, ding, 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 will no longer be limited as to the value of the assets that are owned. That is a significant piece of information, primarily because for two reasons. The first relates to the home place. It's very common that when the first of two spouses ends up moving out of the home they've been in since 1958 and has to go to a nursing home, then the spouse at home will ultimately end up either moving in with a daughter or going to assisted living. It's very common that they won't stay home alone in the house they've shared all that time for a variety of reasons. And as a result, they want to sell it. Well, if they sell the home and the total marital assets, meaning the brackets are around husband and wife, which is how it works on initial application, if those brackets are still around both spouses when the home is sold, then the husband in the nursing home is going to lose his Medicaid. That's not how it works, though. And so on initial application, they will look at anything owned by both spouses, but following approval, they're not going to look at what's in her name. So what is she allowed to do? She's allowed to actually sell the home, bank the money, have it invested, generating more income for her, avoid all of the ongoing overhead of the house, and now she's much more able to afford assisted living without all of that upkeep and responsibility of the house, and it doesn't impact husband's ongoing Medicaid. Yes, it affects her someday in the future, but half the time that we're doing planning for the first spouse to protect the second spouse, and it's far less important to that spouse that she be able to qualify for Medicaid as long as she gets the care that she needs. Yeah, they probably do care a little bit about the kids and the grandkids, but it's typically a lower priority. The second reason why that note is important is that it's relevant to the planning tools that are used to trigger the first spouse's eligibility. Because if somebody acquires an asset that generates income, which is otherwise permissible, namely an annuity, there is a way to restructure those dollars today in a way that Medicaid permits, which will then pour those dollars back in the future into an account owned by the wife, which, as I just said, is no longer counted. And so a temporary holding spot for those dollars can exempt them in the present and then ultimately lead to them coming right back to spouse following approval. So that rule is an important one. All right. Examples of countable assets. A lot of these things are just common sense options. I do want to pause on a couple. Let's go to number 11, gems, art, personal items. This is one where, you know, I get all the typically sons. Daughters aren't, they don't try to be too sneaky. Sons, for some reason, they all want to get sneaky. And so they ask me, well, can I just buy a $40,000 Rolex for dad and be done with this? Or over on the exempt slide, there's one vehicle that's allowed. And they'll ask, can we buy a Mercedes? Actually, you can buy the Mercedes. But as far as the gems and arts and jewelry and other personal effects which are held for their investment grade, that's not an acceptable solution to the asset plan, because those are not household goods and personal effects. Those are actually assets that were purchased as part of a plan to exempt countable assets in a way that is held for their investment grade. If somebody owns a $50,000 Rolex because it was passed down from their grandfather to their father to the client, that's different. And so there's a lot of room for wiggle here that I'm not encouraging abuse. In fact, I'm encouraging the opposite. But it is important because a lot of our clients have gun collections, Civil War artifact collections. I had one client that had, it's amazing, toy train collection that was worth $200,000 that we were able to get exempted because I was able to document the historical ownership of it. So that's an important piece of all this. The other one I want to call attention to is 10, a non-compliant deferred annuity older than 5 years. What does all that mean? Well, first of all, in 2006, Congress set up a checklist of boxes that must be checked before the purchase of an annuity will avoid penalty. Otherwise, an annuity is going to be treated as an improper transfer for less than fair value and penalized under the look-back rule. So if all the boxes are checked, which I don't have them here, but if you, I think it's 2339 of the manual, if you go and you read them, it has to be irrevocable, non-assignable, actuarially sound based on the person's life expectancy, include equal payments and no balloon payment, and then there's a requirement relating to who the beneficiary named is. If you check all those boxes, then the purchase of that will not be considered an improper transfer. All right. Well, what if you have one that doesn't check all those boxes, but the purchase took place more than 5 years ago? Then, at least in my opinion, and in the cases that I've been able to get through, that annuity should not be subject to penalty because you can't penalize a purchase that took place outside the 5-year look-back period. Okay, great. Well, in that case, Medicaid took the position, and I don't necessarily think it's unreasonable, that all right, it's deferred, so it's got value. We're not going to exempt it and allow it to be excluded from penalty. And so that asset was considered a countable asset because it was non-compliant but older than 5 years and therefore not subject to penalty. There might be some out there that would want to litigate that and argue it should be excluded. I'm not sure how, because if they can access it, they can access it. So that's on the countable list. All right, exempt assets. As mentioned, there isn't a limit other than for someone who's unmarried, a home place equity limit. And then examples of exempt assets. This is actually an important list because this is where a lot of Medicaid planning happens. It's just taking countable cash over 132 and figuring out where it can go. And so everything on that list is somewhere that it can go. The home place, that's a great place because guess what they can do? They can pay off a line of credit or the mortgage. They can put on a new roof. They can redo the kitchen. They can finish the basement. They can do anything they want. And regardless of value, as long as they're married, it does not violate any rule. And so you can literally update your house and apply for Medicaid the next day and be approved. So home place improvement is very common. Item number 7, one vehicle used to transport the applicant or spouse. That's another great example because it's not uncommon for my clients, at least. They have all got a 1998 Crown Victoria or a 1996 Buick, Century. And it doesn't have airbags and it's out of warranty, and the community spouse would be well served having a new car that's safer to drive, that's under warranty and reliable. And so you can trade in the old car and pay cash for the new one. And again, there's no limit to the value you can spend. So she can upgrade from a Buick to a Cadillac if she wants, and there's no harm done with that. You do need to look at section 2308 of the manual, and especially if a vehicle is being purchased for someone who is not married and there isn't a community spouse using the vehicle, Medicaid is going to scrutinize how that vehicle is used and whether an adult child is using it as their primary vehicle. And if so, they would like to take the position that it's somehow countable. I don't necessarily agree with that part of the manual and would fight back on that, but it's there and you're picking a fight if you purchase a vehicle on behalf of somebody who is not married. Other examples, items 3, 4, 5, 2, 3, 4, and 5. The footnote highlights the fact that those are all interconnected. And so starting with number 5, the $10,000 burial exclusion, this is the number one piece of bad legal advice that nursing home business offices give. They tell everybody you can have a $10,000 burial account, but they never ask whether the applicant has any life insurance, and they never ask whether the client has any prepaid expenses at a cemetery or funeral home. The problem with that is that if you have prepaid expenses at a cemetery or funeral home, or if you have life insurance, then it most likely erodes or consumes your $10,000 burial exclusion. And so several months later, when that nursing home Medicaid application is denied and a $20,000 bill shows up based on the bad legal advice of the nursing home business office, they're going to give your client an invoice for $20,000. And so by all means, familiarize yourselves with 2311, 12, and 23, because if you don't track how they all impact one another, then things can go sideways. We already talked about household goods and personal effects. We talked about a Medicaid compliant annuity. We talked about retirement accounts. Just can't overemphasize that. Community spouse retirement accounts, regardless of value, are exempt. And so you cannot, a spouse can have $1 million 401k and it doesn't have anything to do with eligibility, even if it's not making any periodic payments. Under number 10, that's number 10. Under number 9, you do need to be receiving distributions if it's a retirement account that belongs to the nursing home resident. There are some rules about how much that distribution must be, and a debate about how frequent periodic is and whether that's once annual. But take a look at 2332 and be advised that if you have a client paying privately for nursing home care or in-home care, when they might otherwise be eligible for nursing home or CCSP Medicaid because that account is exempt, it might be time to reevaluate whether they're already eligible for Medicaid. All right, in the interest of time, I'm going to move on because we've only got 10 minutes left. The final pillar of eligibility is D, transfer eligibility. This is the 5-year look-back period everybody has heard about. And so the Georgia penalty divisor is $8,821. Why that's important is because if somebody gives, $100 to the United Way, that's not going to result in any substantial penalty at all anyways, because it wasn't made to qualify for Medicaid. But even if it was, if they chose to penalize it, the point is that the only time that your client will have a penalty that rises to significant enough that it affects even 1 month of eligibility is after a gift of $8,821 or more. And so that number, which you'll remember from the slide way back up top, that's what the state of Georgia considers the average cost of 1 month of nursing home care in Georgia. And so for every $88.21 your client has given away, Medicaid's response is, hey, on average, you could have paid for yourself for all those months based on 88.21 as the divisor. And so you gave away 88,000. We're not going to help you for 10 months. Come back and see us in 10 months. And so that's how the penalty is calculated based on the divisor. The rest of this page, we could have spent an hour and a half just on this alone. So, we're going to have to move through this quickly. There are a lot of transfers which are exempt. Take a look at section 2342 of the manual and commit all those to memory, because as you discuss your client's circumstances, hopefully they'll all be etched in stone back there. And when you see a set of facts that ticks one of those boxes, bells will go off. A great example is number 11, the caregiver child exception. So if daughter moves in with mom to take care of her so she doesn't have to go to a nursing home, then after 2 years of her living in that home as her primary residence, mom can give it to her and not suffer any sort of transfer penalty, as long as you can document all of the elements of the exception exist, which, is going into that is beyond this call or this webinar. But there is an exception for that. So be familiar with those. Item 1, super important one, spouses can make transfers all the time. The main reason this is important is estate recovery. If a house is in husband and wife's name and husband goes to the nursing home and after he dies, Medicaid gets to put a lien on his stuff, what should he do? Maybe he should give his interest to his wife so that when he passes, a lien can't get put on the house. And that's actually totally permissible because spousal transfers are not penalized. In fact, post-eligibility, I already mentioned that they actually require, it's not just permissible, it's required that you must give all of the 132 that was in your name, applicant, you must give it all to your community spouse by the first annual review or we'll terminate you. So transfers between spouses permitted and in some cases required. Item 2, transfers by spouse after eligibility. If husband's already on Medicaid, his wife can give away anything she wants because by definition, those gifts were not made to qualify him for Medicaid. And as you can see down under number 10, transfers made for a reason exclusively other than Medicaid. Well, wife must have had a reason other than Medicaid because he's already on Medicaid. And that's really helpful because the family may not really care about whether mom herself might someday want Medicaid. Yes, her gifts do affect her 5-year look-back period someday. And that's why post-eligibility, it isn't uncommon for the community spouse to think about utilizing an irrevocable trust as a planning tool for her, starting a new 5-year clock ticking that doesn't affect him. All right. Other examples of transfers not subject to penalty: purchase of a life estate if the person lives there for at least 12 months, transfer of an asset that's exempt under SSI rules. This one I really wanted to, give the son a good talking to. But I met with somebody last week where the son said, well, hey, wait a minute, if transfers can be made of things that are exempt or under SSI rules, I thought a car was exempt, right? So why can't we go and take mom's extra $70,000, buy a Mercedes that we now can argue is exempt, and then give that to me and qualify for Medicaid? And I had no response to that other than it's super abusive and I don't encourage it because the $70,000 is going to immediately start to depreciate, and I just don't like the idea. But there's an argument you could do that. There's all kinds of arguments like that when you start looking more closely. All right, a lot of transfers that are subject to penalty. The one I want to call attention to here, a disclaimed inheritance, because a lot of y'all do estate planning and probate. It does come up that somebody who's on Medicaid is somehow a beneficiary And the common solution is a disclaimer. And so unfortunately, Medicaid says that taking an action that results in you not getting something that you were otherwise entitled to counts for purposes of this transfer rule, and you get punished, you're penalized for that. Purchase of an annuity which is not compliant is going to be subject to penalty. So lots of these things that people might think up on their own as they're trying to reinvent the wheel to qualify for Medicaid themselves, those are the things that are generally going to be found on the list. All right, so patient liability, how does that work? Well, once you're on Medicaid, the bill isn't just free. So your client is generally always going to owe something. I call it the fair share. They call it the patient liability or the cost share. For someone who's not married, they're generally going to be in a nursing home. And this is where there's a difference now between CCSP and nursing home. If they're in a nursing home and unmarried, they're going to have to give the nursing home all of their income other than a $70 allowance plus deductions for health insurance. Whatever's left, the nursing home is going to get that, and Medicaid picks up the difference. If the person is in the nursing home is married, well, then they also get to do a spousal income diversion to the extent it's necessary to bump the spouse up to $32.59. What does that mean? It means that the final bullet point here is that a husband and wife who collectively have income at or slightly above $32.59 actually could have a nursing home bill that's free because she gets to keep all of her income and all of his income, and Medicaid pays the whole bill. These are a couple of examples of how the nursing home budget is calculated that all the next few slides, you might want to go back and familiarize yourself with these. In this example, my client, this is a current client, the husband has these two Social Security payments, or two income payments, one pension and one Social Security, and the wife has just a small Social Security check. And this is the difference, $3,600 versus $1,200 of what the resident would have to pay depending on if he's married or not. Now, even if he's single, $3,600 is a lot better than $8,000 or $9,000 or $10,000. So qualifying for Medicaid, even though this person has $3,900 a month of income and needs to use a Miller Trust, still it makes sense because from a cash flow standpoint, the two paychecks satisfy the amount that's due, and avoiding the additional expense of 8 or 9 or 10 is a significant advantage. Obviously, if the person's married, that number is much lower because the law protects the community spouse. Community care Medicaid cost share is super complicated. At least I think it is. It's calculated differently whether you're on CCSP at home or in a CCSP personal care home. If you're at home, the formula is very similar to the nursing home formula that I just showed you. The only difference is that the $70 allowance is increased to the SSI number, 794. And so in this example, if a married client is on CCSP at home, the cost share goes all the way down. Remember, it was $1,200 up above. Now it's only $500. And an unmarried CCSP recipient, it's $2,900 instead of $3,600. This is, I guess, depending on timing, might be the last thing I get to. I want to caution you here because there are limits to CCSP once somebody's income gets high enough. My point being that if this person in this example paying $2,900 for CCSP, if they're only awarded 25 hours a week or 30 hours a week, they can probably pay for that privately for $2,900 or less, and they're not actually getting any real meaningful value from being on Medicaid at that point. So there's a time when someone who's unmarried, you have to look at that. All right, if they're in a personal care home, this is the part that's most complicated, and you're just going to have to read it and familiarize yourselves with it because my time is up. And so let's see. Those were all the last 4 slides related to the community care cost share budgeting process, and then I included the myths and pitfalls just as sort of some bonus information. So that's everything we have time to cover. Patricia, thank you again very much. I'm happy to stick around and answer questions as long as folks are here to ask them, but I also understand that our time is up.
You know, there are a couple of questions, but I need to ask Lane how much longer we can stay on here before I.
You guys are good.
Okay, thanks, Lane. So I'm just going to read a couple of the questions that have come in, Dan, okay?
Sure.
The first is, how is the receipt of loan principal not a conversion of a resource?
I'm sorry, can you say that again?
How, this was back to where you were talking about conversion of a resource versus, and the question is, how is the receipt of loan principal not a conversion of a resource?
If I understand the question correctly, I think that it really gets down to basis and the return of somebody's principal, and that from a tax standpoint shouldn't be considered income because it's return of principal. Sometimes I just have to tell clients that's what the law is. That's what the policy is. And so if somebody lends somebody money pursuant to a promissory note, Georgia policy says that 100% of the deposit received is income for purposes of the Medicaid eligibility budget, even though the IRS would not count the principal portion as income from a tax standpoint. That's just the rule. And it's actually an important rule for them to apply consistently, because promissory notes are often used in some of the more complicated types of Medicaid planning, where I need to know that Medicaid is going to consistently treat the payments coming in as income, because it's part of the way we've set up the plan. I don't know. I hope that helps answer it.
Yeah. Now, the next question is, do you need to collect 5 years of documentation from your client?
My understanding is that the law permits Medicaid to ask for that, but in my experience, they will not ask for that unless you give them a reason not to trust you. And under normal circumstances, they're only going to ask for 3 months worth of statements, because the law actually requires Medicaid to review an applicant's eligibility for both the month of application and the 3 preceding months to see if they might be retroactively eligible. So they will always ask for 3 months worth of statements. This is an important piece of information, because I have a client right now who I was just able to get approved, who a transaction happened in January, and I forget the exact way the months worked out, but 4 months back, well, I should say 3 months back, something happened, which I know from a policy standpoint is not problematic. But if it was on the bank statement that we gave them 3 months behind our month of application, I knew Medicaid would nitpick it. I advised the client, we should wait a month, file in June instead of May, because the February statement that begins in January includes that problematic reimbursement that I know they're going to nitpick us about. And so I leveraged the rule that this question addresses, which is they're only going to ask for 3 months worth of statements. Now, if that thing that happened in January was illegal and problematic, no, I would never have recommended that to hide it. But when I know it's not problematic, then there are times when it makes sense to do that.
Got it. You know, there are a couple more. I'm going to add the ones that are in the queue. I'm going to ask, and then we're going to have to stop for the rest of the attendees, just to be respectful of everyone's time. If a community spouse is the beneficiary of a trust that does not name the Medicaid spouse as the beneficiary, are the trust assets considered a resource that can reduce Medicaid eligibility?
The general answer is going to be yes. The general rule is that what I call the any circumstance rule. Now, if that spouse is disabled and it's a special needs trust, then no, and there are exceptions. But in general, from an eligibility standpoint, a spouse is considered a deemer. So asset, like I said, there are brackets around both spouses. And assets which are available or could be spent on either one of them under any circumstance are going to be considered accountable for purposes of the eligibility determination. Now, this is when you get into questions about trusts and how they can be uniquely worded to try and dance around the minds, it's maybe a little bit precarious, but no, you can't. It also depends on whether it's self-settled or third-party money. So it's really beyond the scope of this conversation to figure that out, other than to say if it's first-party money, then it's for sure going to be countable. And third-party money, then it depends on whether the trust has a ascertainable standard and a HEM standard. And I'm not sure if everybody's following me, but
Yeah.
The general answer is yes, be careful about that.
I have two more questions. How is a life estate in a home place currently treated by Georgia for estate recovery purposes?
Because of the last clause for estate recovery purposes, I won't worry about how it's deemed for eligibility. For estate recovery purposes, there's what the Georgia Department of Community Health has included in the definition of estate for purposes of estate recovery. And then there's real life. So the state of Georgia Department of Community Health does on paper still take the position that they should get to recover against a life estate. However, those who engage counsel to push back on that and document that the estate does not actually have anything of value to be subject to recovery because the life estate ended when the applicant did, then my understanding is that DCH backs down on those requests.
Okay, last question. I had a client ask if she could execute a joint survivorship warranty deed, adding her son to the deed of her property. Assuming the 5-year look back does not become a factor and she received Medicaid, would the surviving child face any Medicaid recovery issue after her death?
So the folks at Georgia Medicaid, I'm not any more knowledgeable than them about the minutia of Georgia real estate law and the various unique ways that property can be held jointly, whether it be as tenants in common, tenancy by the entirety. I don't even know if we allow that.
No.
Joint right of survivorship. I can tell you how Georgia Medicaid looks at this as a practical matter. If the parallel is to a bank account. If mom owns a checking account and adds her son to that checking account, then under section 2334 of the manual, mom has not, I repeat, not taken an action which triggers a penalty because 100% of the asset is still available to her and belongs to her. And also because they understand that parents often add a child to their checking account to help pay bills. So just adding a child to a bank account does not trigger the 5-year look back period. Using a survivorship deed with respect to real estate, all that really does is convert title to the equivalent of a checking account, where whoever survives longer gets the asset and the checking account or the real estate is a non-probate asset. And as a result, in my experience, and again, I didn't see anybody from DCH who was on the attendee list, which I took a look at. But if there is anyone, I don't know if this is going to impact how they look at things. But as of right now, I've never seen DCH impose a penalty for the addition of a child to title with right of survivorship. And that's just, as a practical matter, how they do it. The final piece of that question is, all right, so let's say they do that. And whether you get outside 5 years or as a practical matter, they don't penalize it anyways. What happens if mom goes on Medicaid and then dies? Is the property subject to an estate recovery lien? And that's where you get into another screaming match with the definition of estate in the estate recovery regulations versus property law. And so the definition of estate for purposes of estate recovery includes real estate passing by survivorship. And therefore DCH would take the position that they are entitled to recover against it. But that son could go and get a lawyer and fight with them about how that asset passed outside of probate and shouldn't be subject to estate recovery. That's a big mess. In my experience, I don't really like solving a problem by creating a mess. And I would often talk with that family about other solutions as to what to do with that house besides the solution that was proposed here. Simply adding a child with survivorship and then hoping to win the battle about estate recovery later.
Well, that's all we have time for. I know we've gone over. I appreciate everyone for sticking around. Dan, Lane, I appreciate you both for sticking around, and have a great summer, everyone.
Awesome. Patricia, thanks again.
Ladies and gentlemen, this does conclude today's webinar. Thanks for joining and have a great afternoon.